Okay, I see Mr. Burnett.
I'm sorry.
I lost you all. Can you hear me?
I'm sorry, Your Honors. I've lost. The video is frozen. I can hear Mr. Sales. And I can see Mr. Sales, and I can see your images, but nothing is moving, and I hear no audio.
Same thing. Thank you, Mr. Burnett. I'm in the same boat. Can see Your Honor's pictures, but can't hear you. Can see and hear Mr. Burnett.
I think we're back now. Hopefully.
Yeah, things are moving again. I can hear y'all.
Yeah, I just got a flash. Internet connection's unstable, so it's even unstable here at the court.
Okay. Okay, Mr. Sales, Mr. Burnett. Mr. Burnett, when you're ready.
Thank you. This is a good sign, Your Honors. May it please the court and
Yes.
good morning. My name is Jason Burnett. I'm here on behalf of the appellant, R.J. Reynolds. I would like to reserve 5 minutes. Of
All right.
Also, pleased to be part of your last argument this morning, Your Honors. We've raised 4 issues on appeal. The 4th issue is the applicability of the 1999 amendments to the punitive damages statutes. Our argument on that issue was foreclosed by this court's decision in Evers. Your opinion in Evers, Judge Morris. I'm not going to say anything more about that issue, but I do want to raise 2 points about that, an update and a request. Since the briefs have been filed, the Florida Supreme Court has granted review in the Sheffield case, which is the 5th district case that disagreed with this court's decision in Evers and the other 2 district court decisions on this issue. And so it is pending in the Florida Supreme Court. Briefing is underway. And so however you decide the other issues in this case, I would ask that in your opinion, you provide some basis for us to take advantage of the ruling from the Florida Supreme Court, no matter what that might be. There are 3 potential ways you could do that. You could hold this case. That's not the relief I'm requesting, but you could hold, since the 2 punitive damages issues in this case would be affected by that ruling in Sheffield. The relief I am requesting is the second option, that you simply certify a conflict with Sheffield. The Sheffield court certified a conflict with Evers, so I think it would be fair for this court to certify a conflict.
That's the most logical one. Yeah.
Yes, thank you, Judge Morris. Thank you. At a minimum, I believe for Florida Supreme Court jurisdiction, you would at least need to include a citation to Sheffield in order to give us tag jurisdiction in the court. But we do ask that you certify a conflict on that 4th issue. So turning to the 3 live issues, the first issue, of course, is the refusal to give the instruction requested on the statute of limitations. And that instruction has been given, or has been held to be required to be given by the first DCA in the Jewett case, which we've cited, the very same decision that we proposed to the trial court in this case. And a very similar instruction was given by the trial court in the Frazier case, the 3rd district case. In the 3rd district, the Frazier court held that that instruction was a correct statement of the law because it comes directly from the Engle decision.
I don't understand that anybody really disputed that in this case, did they?
That's true, Judge Morris. Even in the briefs, Mr. Sales acknowledges that manifestation 1 is the standard. That comes from Carter. Number 2, a diagnosis is not required. Mr. Sales, of course, objects to the jury being instructed as to that, but the legal standard does not require a formal diagnosis.
It seems to me the basis of his objection was, hey, we have a standard jury instruction that seems to address this situation. Let's not mess with what the Supreme Court has told us to say. Now, I have to tell you, as a trial judge, I said that to trial lawyers many times. Why am we going to mess with what the Supreme Court told us to say? So, but if it's not disputed, I mean, nobody really disputed this. How do you claim that you've been thwarted in your ability to mount a defense in this case if your opponent's not even arguing that?
I'm sorry, Judge Morris, I misunderstood your question. I thought you meant whether it was disputed on appeal. Factually, it was a major factual question in this case, whether Ms. Durrance knew she had COPD because she was.
Yeah, sure, of course. Yeah, and certainly when the diagnosis occurred is relevant just sort of as a spatial issue. But I don't recall reading anywhere that anyone said at any point in time that the diagnosis is the operative event. Now, if I've missed that, you need to help me with that, but I don't recall reading that.
Okay, so 4 times by my count, plaintiff's counsel told the jury that because she had not been diagnosed, Ms. Durrance could not know that she had COPD. And that's at page 908, which is the opening statement, page 3352, which is the closing argument.
So is the implication of that language that without a diagnosis, she couldn't know?
Correct.
Okay, so is that your supposition or somebody actually made that argument?
Now, the argument, and I can read the statement as made to the jury. Quote, this is on 3355, talking about the statute of limitations defense, plaintiff's trial counsel. She hadn't been diagnosed and her physicians didn't know she had it. On the earlier.
Well, but isn't that fair comment on the evidence? That's not a statement of the law. That's just a fair comment on the evidence, which we do in closing argument, all the time.
But the jury, so you referred to the standard instruction that was given in this case.
Yeah.
It's a standard instruction that applies in any case where there's a statute of limitations defense. This is a special case. It's a creeping disease case. So it departs from the normal case where a cause of action accrues under general principles. There is a special standard that applies. The jury was never instructed on that special standard, which is manifestation. And that manifestation standard, as all agree here, includes the legal requirement that a formal diagnosis is not required.
So here's the $64,000 question, because I read y'all's briefs and to some degree you're very slightly talking past each other insofar as everyone agrees that something, pick a word, hang a word on it, something has to be apparent for the statute of limitations starts to run. What that is, it is short of a diagnosis, okay? Because you're right, under the law, it doesn't have to be a formal diagnosis COPD, but it has to be something that gives rise to the cause of action, because that's ultimately what this trails back to. If you draw back what statute of limitations are all about, is when did your cause of action accrue? The suggestion that you're making here, which is that, well, you have to have a manifestation, to me is a little bit troubling, because a manifestation of what? There's no way to totally divorce the notion of manifestation from diagnosis conceptually, right?
I disagree with that.
Can I add to his question just a little bit?
Of course.
Just a little bit, because you could be asymptomatic and the first time you learn is that a diagnosis. So it's not an absolute, okay? If there are other symptoms and other things that have occurred, the clock starts sooner. But if you're totally asymptomatic, you got no health history, and you show up and you get some bad luck, bad news, could start right then, right?
I agree, Your Honor. In that factual scenario that you're describing, the accrual date would be the date of diagnosis. So we do have to show manifestations. And to get to your question, Judge Lucas, this is from the Frazier case. I don't disagree with how the Frazier court describes it. It's pertinent symptoms and effects of the disease that reveal themselves to the smoker.
You see right there how even with that subtle use of language, it's a constellation of symptoms of the disease. All right. So you don't have to have a formal diagnosis, but what? You have to have a sufficient quantum of symptoms such that a diagnosis could have been made. Is that the standard?
I think that's a fair description of it. I will say in all candor, this has not been elucidated further, as you're suggesting, in any of these cases. And what the case is
very problematic, because what you're asking for is a jury instruction. You are saying, look, this jury was improperly instructed on an issue of law. And of course, you know, we all know, for a brief time, I was actually on this civil jury instruction committee. They take it very seriously what you are instructing a jury upon. So to say, for us to hold that this jury was improperly instructed without giving some guidance as to what that instruction needed to be as a matter of law, I don't know that we could do it.
Well, we did propose an instruction, and the instruction that we're saying should be given is the instruction we proposed.
Right, and which
nobody was impressed with it.
Ties right back to my point. That instruction, I don't know that it really meets what the law is. So
okay, let's not let the best be the enemy of the good, or the perfect enemy of the good.
Okay.
There's cases that say if you propose a faulty instruction or an instruction that's confusing and misleading on its face, no abuse of discretion to refuse to give it. That's not what happened here. We proposed an instruction that informed the jury that it has to be when the disease first manifested and the actual diagnosis is not the critical date. There's no dispute that that's an accurate statement of the law. So it's not erroneous, and it's not.
I frankly think unless the victim actually has an MD, they're not going to really know that.
Well, my view is similar to Judge
I wouldn't know it.
My view is similar to Judge Lucas's view, and I can tie this back to the facts in this case. So it does need to be symptoms and effects that would lead to a diagnosis, but we're talking about a layperson's knowledge and constructive knowledge too, right? Not just what they knew, but should have known. And so here in this case, for example, Mrs. Durrance had bronchitis without dispute. She had it repeatedly from 1982 to 1989. Now, the factual dispute in this case just comes down to a characterization. Plaintiff's characterization was that was periodic bouts of acute bronchitis, not chronic bronchitis, which is COPD. Defense characterization was, well, actually, this was chronic bronchitis, not merely periodic bouts, because there's a medical definition that plaintiff's expert gave. Chronic bronchitis requires 3 consecutive months and 2 consecutive years. And we showed through the medical records that she actually met that. Now, Ms. Durrance isn't going to know that medical definition of what qualifies as chronic bronchitis, but she knows she's experiencing the symptoms of bronchitis for 3 months at a time for 2 consecutive years. And Dr. Burns, the expert pulmonologist here, would say that's chronic bronchitis. Now, they disagree that it is chronic bronchitis. They say it's actually acute and just periodic. But that was a factual question. And the Florida Supreme Court's decisions in this area, such as Carter, make clear that these are factual questions for the jury. Part of your questions, I think, get to the point of, did we have a factual basis for this instruction? You know, Mr. Sales never moved for DV on the statute of limitations defense. He didn't renew a DV. He didn't cross appeal from the denial of a DV. This was a proper factual question to the jury. When our trial counsel made the argument that I just made about these 3 months over 2 consecutive years, there was no objection from Mr. Sales that somehow misstated the testimony. So there was a clear factual question for the jury on whether Mrs. Durrance knew or should have known she had COPD under the manifestation standard. And as for guidance to trial courts, you may write an opinion that says what Reynolds proposed was not sufficient. There needed to be more.
What's so interesting about this is we're holding her to a knew or should have known standard. At the same time, we say a diagnosis is not the operative event. Yet she was under the treatment of physicians who were, treating these things, and not one of them was smart enough to call this.
Well, I disagree.
So how was she supposed to know?
Well, let me clarify that, because that's not exactly true. So in a 1989 medical record, she is diagnosed with bronchitis with an asthmatic component. Dr. Burns, again, plaintiff's expert, testified that asthmatic bronchitis can be a synonym for COPD, chronic bronchitis, COPD. And I've already explained how her medical records do have recurring bronchitis that can be a diagnosis. We argued to the jury that she had a diagnosis. This is not a case like Frazier, or even the conflict cases in the Carter decision, where someone goes to a doctor and is diagnosed with something other than the disease that becomes their cause of action. That's not what happened. She went to the doctor reporting signs and symptoms of bronchitis, which became—
None of these doctors also said, hey, you might have COPD. Could be. Should we check it out? Or, none of that conversation was had. So again, we're asking her to try to understand that the very doctors that she was going to didn't bother to say, hey, could be, maybe, might be, that conversation, at least in our record, wasn't had.
Well, let me clarify that, because there's not a single medical record that says here is the point in time where she is diagnosed with COPD. That wasn't plaintiff's position either. There was a 1994 record that says she has a history of COPD. And plaintiff's expert Dr. Burns testified that in 1992, she had an x-ray that at that time, in his view, first showed the signs of lung changes that would reflect COPD.
But isn't the standard that she should have known? She should reasonably have known, right? So all this after the fact testimony is fun and all, but what's that got to do with what she reasonably knew? And that no doctor that she was going to and under the care of at that time made any suggestion that, hey, I could have some bad news for you. This could be a possibility. We have no record testimony of that.
We have medical records, that shows that she was suffering from symptoms that are the same symptoms as for chronic bronchitis and COPD.
And she, as a non-healthcare, qualified person, should have known, or reasonably should have known, that was a possibility.
Yes, Your Honor, because if presenting
would you have known that?
The question is whether she knows she's suffering from symptoms that manifest themselves in a way to supply a causal connection to the product. That's what gives her a cause of action. That's what gives her a cause of action. If you were to hold that you have to have the knowledge that you are suffering from the actual medical condition, then no layperson would ever be subject to a statute of limitations defense.
No, it's new or reasonably should have. It's the reasonably should have where I'm focused. And I'm just one, and I guess the point you made is a rational one. I mean, yeah, even reasonably should have known is a lot to ask for non-medically oriented people. You know, really, seriously, how are we supposed to know this?
Well, her medical records do say that in 1989, she was diagnosed with asthmatic bronchitis. She may not know that qualifies under the medical definitions.
Well, not everybody agrees with that.
And that's true too. And that's true too.
So not only would she not know that, but not everybody agrees with that. So, you know.
That's why these questions are left to the jury and made a fact question.
Yeah.
And again, I'm just making the point. There wasn't a DV motion on this. There was a factual dispute about when her cause of action accrued, and there was no suggestion, no motion made to say that we didn't have a viable defense. Mr. Sales has made the argument that you have to have a factual predicate for the instruction that you request. But besides cases like concurring cause cases or road hazard cases, we're not talking about those kind of discrete issues. We're talking about a defense. For a claim or defense, you have to move for directed verdict if you're going to say that there's no evidence to support the claim or defense. But that was
Burnett, can I ask, have you located other case law where, either in Florida or elsewhere, where the failure to alert the jury that something less than a formal diagnosis, the failure to positively state that within a jury instruction was erroneous as a matter of law in the context of a creeping disease?
Other than Ingle and Jewett, and the Frazier decision from the 3rd DCA agrees with Jewett that even though this statement in Ingle is related to the class cutoff date and not the accrual date for statute of limitations purposes, that it makes sense to use the same requirement. So it's Frazier, Jewett, and Ingle that would support the no need for a formal diagnosis for manifestation. It does make sense if you look back at Carter and how they define manifestation. You know, the accumulated effects of the deleterious product reveals itself in a way. You don't need a diagnosis for that. You could know you're suffering from shortness of breath, from coughing, from lung sounds when you cough. You know when you go to the doctor, you've been diagnosed with bronchitis three months in a row for 2 years, even though you may not know, oh, that's what a doctor would call chronic bronchitis.
Right, but this just kind of turns back to my concern about what it is. You know, you're going from not telling the jury that a formal diagnosis is not necessary to this manifestation of something, which ultimately is of the disease, which really means of the diagnosis, which I read the proposed jury instruction and I foresee a host of juror questions coming to the trial judge saying, was the date that this accrued when she first began, the first time she had bronchitis, the third time she had bronchitis, the fifth time she had bronchitis? I mean, what do they do with that? Because statute of limitations are heavy medicine, right? I mean, you're barring somebody from access to court, and the need to have a firm, bright line accrual date is important, especially when you're asking a jury to determine it, don't you think?
Mr. Burnett, excuse me a moment. I want you to answer Judge Lucas's question, but I want to remind you you're into your rebuttal time.
Holy cow, that went very quickly. Okay, well, I mean, the manifestation is not a bright line. It's just not. And that's the test from the Florida Supreme Court and Carter. It's a fact question for the jury based on the accumulated effect. So to the extent you're suggesting we need a bright line, the Florida Supreme Court has said definitively there's not a bright line in this area. Thank you, Your Honor.
Mr. Burnett, you'll have 3 minutes on rebuttal, okay?
Thank you.
And if you could mute your mic. Mr. Sales?
Good morning, and may it please the court, I represent the plaintiffs on behalf of their late mother estate. I want to point out before I begin that a lot of what I have to say, particularly in response to some of the court's questions, is going to sound as though I'm correcting my friend and my opponent. But I do think it's appropriate and necessary to do that in light of some of the things that they said in their reply brief as well. They have told the court many times in oral argument today that the Frazier decision supports them. They've also told the court in their reply brief, I believe it was, that if you affirm here, your honors will be an outlier. We dispute that for reasons not only of what Frazier had to say, but also for reasons of what this court did when it followed Frazier in the Damianicus case. But I want to get right to it because there was a jury instruction issue in Frazier, and part of the language that was proposed here was used in Frazier. And at the very end of the case, at the end of the decision, it's a little bit hard to put it together because it's separated by a long discussion about the expert for Philip Morris. But this is what the third DCA said. Mrs. Frazier's complaint further narrowed her disease and medical condition to COPD/emphysema. That would be true here. The limitations instruction and the counterpart interrogatory on the verdict form should have been similarly limited as Ms. Frazier proposed. If you go back to the opinion earlier, they quote the instruction that was offered by the plaintiff. And the standard for upholding the limitations defense that the trial court did not give, but the third DCA should have given, should have been given, is quote, whether the plaintiff knew or should have known in the exercise, or should in the exercise of reasonable care have known on or before May 5, 1990, both that she had the COPD and there was a causal connection between her smoking and her COPD. That's our instruction with very few wordsmith changes. And the third DCA held that that was adequate. It did so after a long discussion that answers many of the questions that your honors have raised this morning. And quite interestingly, in Damianicus, which is 155 Southern 3rd 453 at page 463, I believe it is, this court not only followed Frazier, but it indicated the key point in Frazier, which is that we can talk about manifestation in a moment, but the key is, has enough happened so that the claimant knows it's time to sue? Because you're exactly right, Judge Lucas. We didn't cite it as supplemental authority, but because it didn't really add anything, and I will after the argument if your honors think it's appropriate. But Justice Muniz just said that a couple of days ago in that RR case. The whole point is you have to know, you have to be able to define a point. And their position in this case is one that leaves it very amorphous, not only because they use the word manifestation somewhat indiscriminately, more on that in a moment, but also because they can't tie it to anything. The thing that they tried to tie it to in the reply brief is this asthmatic bronchitis. The record is absolutely crystal clear that this woman never met the definition of chronic bronchitis, which was undisputed, as revealed in 2 public health documents that were admitted to the evidence through our expert and shown to the jury. There has to be not the straddling of a 3-month period over 2 years, which is what they tried to argue to the jury, but there have to be, for the technical definition to be met, for COPD, which is in our instruction, the agreed upon portion, for chronic bronchitis to be present, there has to be 2 3-month periods of relentless, unrelenting, productive coughing. And this record never disclosed that. And counsel says, well, I should have moved for directed verdict. There was a discussion earlier today about whether or not somebody should be moving for directed verdict in a very different context. And there were questions about whether it was a good strategy decision or not. But I submit to the court, it's a very good thing for someone occupying my position in a case like this not to move for directed verdict, particularly where the evidence was overwhelming.
Well,
in
of
our
course,
favor.
but that other case was a criminal case. This case is a civil case, and that's a whole world apart.
Absolutely, but just talking about trying to crawl inside the mind of the lawyer, and I was the one there, and I can tell your honors, there's a good reason, obviously, that we didn't do that. But getting back to Damianicus, this is what the court quoted from Frazier. The issue was not whether Ms. Frazier had the creeping stealthy disease, COPD emphysema, before May 5, 1990. The issue was whether she knew or reasonably should have known enough to permit her to commence a non-frivolous lawsuit against the defendant. And we threw down in our answer brief and asked Mr. Burnett and his client to identify that period of time, the very specific point in time when the law teaches us, because it is an absolute bar, that somebody has to know that they need to sue. And again, to be very clear on that, the agreed upon portion of the instruction in this case, the agreed upon portion based on the standard, was they had to show by the greater weight of the evidence that she knew or by the use of reasonable care should have known before May 5, 1990, that she had COPD, and there was a reasonable possibility that her COPD was caused by smoking. And the problem with their special, sorry.
Mr. Sims, I was going to ask, and this may actually tie into what you were just about to say, because I've got a very quick two-part question, and it all pertains to this first issue. The first part of the question is, in light of the court's ruling below and the Jewett case, for us to affirm here on issue 1, would it be necessary for us to certify conflict with Jewett? And if we do, tell me what is problematic about the instruction that they proposed such that it would be appropriate for us to part company with the first DCA?
I don't think you have to certify conflict because with respect to Judge Makar, he has a very interesting comment in his opinion, which I cite frequently when the courts reject this instruction, as they often do. It's footnote 6 of the opinion. And he basically says something like this, I'm not saying this is the best language and maybe they could have done a better job and impliedly when you go back for retrial. And I would just submit to your honors that, occupying our position, we want the trial courts to use the best possible language to protect the rights of our clients. And I am not saying that they could not have formulated an instruction, could not have proposed an instruction that was free of argument, that would have elucidated similar principles. But what they did here, and there's no other way, just using the sentence diagramming techniques that we were all taught as children, there's no way here to read this instruction as to saying anything other than the date of the diagnosis is not critical. And that is not only an inaccurate statement, it is at least a misleading statement, because the important thing, as we've heard this morning, is the date upon which someone can draw a connection between what they're experiencing and the disease. And I agree with Mr. Burnett. It wouldn't have to be that she said, aha, I've smoked I've coughed productively for 90 consecutive days. I've had two such periods in 2 years, and therefore I have COPD. She wouldn't have had to make that recognition, but she would have had to known that she was experiencing those symptoms that met the technical definition. And there are repeated assertions that our expert agreed with them on that. And what I urge the court to do as a shorthand is to look at pages 2465 to 71 of the record and see if your honors think there's an agreement or concession on the part of our expert that this lady even had diagnosable COPD. Getting to your honors' second point, why does it matter? It matters because, we can't blame ourselves because none of us wrote the opinions in Engel or Carter, but it is absolutely drop dead clear. If you look at Judge Chacon's opinion, Judge Gross's opinion in Chacon, which was affirmed on this point by the Supreme Court, that when Judge Makar talks about manifestations in the limitations context in Jewett, he just got it wrong. There's two types of manifestation, and that's why it's confusing. One is the type that's necessary for class membership, where the disease need merely be present in order to be in the class, because you can be an Engel class member and have a time-barred claim. That can happen, no question about it. But the other one, and the fact that the important part of the instruction here is the drawing of the connection between whatever that manifestation is. Counsel talks repeatedly in his brief and argument about symptoms of COPD, but that isn't what we were dealing with here. We were dealing with a set of criteria that had to be present. Whether the claimant understood the nature of the criteria or not, she had to be aware of the facts that would support the diagnosis.
Some of this may just be inherent in what it is that we're tasking juries with deciding, which is tell us when the cause of action accrues. When does the cause of action accrue? Well, it's a legal determination of when the cause of action accrues.
That's a fair comment, but it shouldn't be with the word. And I would submit, I don't want to speak badly of our jurors. We need them. But I don't think, on behalf of my clients, we certainly did not want this case to rest upon a jury determination of whether or not something had manifested, when we all know, even in Engel litigation, even the Florida Supreme Court uses the words differently for different contexts. And what they're asking your honors to do is to apply the definition of manifestation that actually is the definition that does not fit here, the one in Engel, It's talking about class membership. To be sure, the Supreme Court has also used that term when referring to limitations in Carter. But the additional point, and the reason there is no error here, the additional point is the importance of the drawing of the connection between whatever the manifestation / symptom / condition, cough, whatever it is. The importance is the ability to draw the connection between that and something which prompts or should prompt someone to sue within 4 years. And I would just point out, since your honors, and particularly Judge Morris, have focused on the facts, it should not be lost on the court that while this court has agreed conceptually with the idea that there has to be at least enough for you to know, hey, it's time to sue, that in September of 1990, this woman was not only given a clean bill of lung health, but she was also sent a letter by her doctors after the supposed limitations trigger. She was actually sent a letter by her doctors informing her of the negative findings of her exam and a copy of the exam report. And I just would submit to the court, it would be extraordinary in the context of this case, and it's another reason for not certifying, because the facts did not support the defense at all. It would be extraordinary in this case for the court to suggest that this woman had some obligation to sue months before doctors were telling her, after a series of repeated exams, x-rays, clinical findings, that she was doing, at least in terms of her lungs health, just fine. I don't know how much time I have left because I made a mistake.
Well, I'd like to shift gears because I'm worried you're going to run out of time, and I want you to address.
Dale, you have about 7.5 minutes.
Okay, you're in good shape. So what I want to do is talk about the punitive damage ratio to compensatory damages, the 16-to-1 that has been advanced. And I don't know that there's any cases in Florida that have a ratio that high.
I don't think, well, there are Engle cases where there have been higher ratios. There are no reported decisions on that. I think the key point is to remember, if I may, Your Honor, that the burden here on Mr. Burnett on behalf of RJ Reynolds is to show the court, they acknowledge the expression that this award is grossly excessive. I know you've asked me specifically about the ratio, but it's part of the same inquiry. Justice Stevens, in his opinion in TXO, likened that to the analysis that's often used in the context of remitters. Is there some judicial eyebrow that should be raised? And that's in TXO. There's no mystery here. This panel, members of this panel, the Florida Supreme Court, the 11th Circuit, the United States District Courts in Florida have all upheld variously punitive damage awards that dwarf this one for the thing that this jury punished RJ Reynolds for. What were they punished
number for? Though, but not relative to the compensatory damages that
I'm getting to that because the Supreme Court of the United States, which is the governing authority on this question, because remember, we talk about these things about ratios, but what they're arguing is that this punitive damage award offends the due process clause of the 14th Amendment of the United States Constitution. And what has been told to us repeatedly is that it's not the numerical amount of damages awarded, and it's in all four of the key cases, TXO, State Farm, and Williams, and the other ones out of my head for the moment, that what matters is the potential harm. And there's an obvious reason for that. And, you know, Mr. Burnett says in his brief, well, that doesn't really apply here because this is a different kind of case where that was first stated by Justice Stevens at TXO. The reason he's wrong on that is if you look at Williams versus Philip Morris, a cigarette wrongful death case, and I'm going to respond to Your Honor's question just very directly in a moment, a cigarette wrongful death case, the United States Supreme Court said the same exact thing, that what matters here is not just the actual harm, but the potential harm. And what was the potential harm here? The potential harm here obviously included the death of Dorothy Durrance, who this jury found was killed as a result of wrongful conduct, meeting a very high bar, recklessness, conscious indifference, one of those four standards that the jury was obliged to find were satisfied by clear and convincing evidence. So what happened in Williams? What happened in Williams, and this is sort of illuminated if you look at footnote 10, I believe it is, of the Townsend decision, that was the one case where there was a remitter of a large punitive damage award. If you look at what happened in Williams, after it went back to the Oregon Supreme Court from the United States Supreme Court, it ended up upholding an $80 million, 79 and something million dollar punitive damage award on $800,000 of compensatory damages. And that review was sought on that. The Oregon Supreme Court was asked to apply the standard that the United States Supreme Court further illuminated in Williams. They did so, and that punitive damage verdict and award stands to this day almost 100 to 1. And is there a Florida case that says that exactly? We cite the old asbestos case. They say it's no good anymore because the Supreme Court of Florida didn't have the due process body of law that's developed since. But we can take some comfort in knowing that Gore had been decided before then, BMW versus Gore, and the Florida Supreme Court in Ballard upheld a ratio of 18 to 1. So from the perspective of due process, the award obviously does not offend the Constitution. I don't want to spend too much time arguing about the ratio, but if you just actually look at the way that this case was tried and what Reynolds itself told the jury, that if you were to base this off of the compensation to the individual claimants, if you were to base it off the compensation to the individual claimants, the number that they asked the jury to consider when basing its punitive damage award was the entirety of the compensatory damage award and not the amount that was reduced. That was also the formulation that is to be used in the old punitive damage statute, which Your Honor, Judge Morris in the Evers decision had held should apply. I do want to say one thing, because in their reply brief, they make it sound as though they sought relief under the old statute and that the trial court committed some kind of error for failing to limit our punitive damages to 3 to 1. As we say, it should be 6.5 to 1. But you can search the entirety of the record. They have never asked in this case, even in their initial brief or in the pretrial proceedings, they never asked the trial court to perform the analysis that is required under the old statute. And that's typical in Engle litigation. It's a matter of importance because I don't know if in fact that's what Mr. Burnett's going to say, that he did raise the old statute. But if you look at their brief, they have never raised the old statute as something that the trial court failed to do in analyzing whether or not this punitive damage award failed to satisfy the earlier statute. I would just say this about that as well. It's a matter of some concern to us because we know that Judge Cook is due to retire, particularly after the discussion we've heard today about successor judges. So if Mr. Burnett comes back and says it failed on that ground as well, it's not something that was properly raised. On the last issue with respect to certification, whether there should be certification with Sheffield, I am counsel for Mrs. Sheffield in the Florida Supreme Court. We are there in part because Evers conflicts with the decision in Sheffield. As your honors probably know, it's a 3 to 1 split with Evers, Conzelman, and the Allen case from this court, the 1st and the 4th district going the same way as Evers, and Sheffield in that instance being the outlier. There is clearly a conflict. I was a little bit surprised, and I'm happy for Mr. Burnett's acknowledgement today that the issue is foreclosed, because what he said in his reply brief was, quote, plaintiffs do not attempt to defend Judge Morris's opinion for the court in Evers. And we cited, obviously, I don't know if the court is considering revisiting that rule in Rule 9.331. And this is a quote: the suggestion that each 3-judge panel may rule indiscriminately without regard to previous decisions of the same court is inconsistent with the philosophy of the district courts of appeal and so on. It doesn't sound like the court would be considering doing that, but obviously we're opposed and don't think the law supports this decision in this case, which we're asking for a summary affirmance to be delayed pending disposition of Sheffield in the Florida Supreme Court. The only thing that I would urge the court to do, if it thinks seriously about whether or not there should be certification here, is to search the record and see if they're actually preserved on this point. I acknowledge we didn't brief it, but they're relying on the new statute. The new statute requires that they do things prior to trial. We didn't brief it because it's just so clear that I wasn't expecting, obviously, what I just read to your honors about a challenge for our failure to defend the court's prior decision. But they were obliged, if they were seriously seeking the application of the prior statute, to provide the court in advance of trial with non-hearsay information showing that they had paid prior awards They didn't do that. They did it very curiously. I've never seen this before when they moved for directed verdict. And I think that the court would have, if it considers that and is considering certification, I think the court would have should have some concern about whether or not they actually followed the procedures of the statute that they say apply. Finally, I expect Mr. Burnett to say in response to that, and your honors may not remember this, but in Hillsborough County, an in-bank panel of circuit judges held some proceedings and issued some orders that were to apply to all of these cases. There are means by which they can be overcome. One of the orders that was entered prior to trial in this case was an order that the court would follow the Allen decision before Evers came out, rendering the later statute inapplicable. But I do think there is a legitimate question here, since it's been argued the way it was argued in their reply brief, as to whether this matter is properly presented to the court. And obviously that would impose additional burdens on them should they seek further review in the Florida Supreme Court. Thank you very much.
Thank you, Mr. Sales. Mr. Burnett, you're muted, sir.
I did it yet again. Can you hear me now?
3 minutes on rebuttal, sir.
Thank you, Your Honor. To start with the last thing that Mr. Sales said, there's a vague suggestion that we did not preserve the issue. There is an all cases ruling in Hillsborough County that predated this trial. We moved for a directed verdict. It is preserved. We filed the material showing the prior punitive damages awards paid both in the all cases proceedings and in this case. It's $329 million in prior awards paid. That issue is preserved. We noted that Mr. Sales did not defend the Evers decision, just to point out that we weren't going to address the merits of it. So we're not faulting him for not defending. Evers is binding on this court, but we weren't going to go into the arguments in our reply brief. That's the only reason that statement is there. So the court should certify the question of the applicability of the 1999 amendments to make sure that like cases are treated the same way. And that can be done by certifying this question so the Florida Supreme Court will have jurisdiction over this case. As for the limitations issue, what rationale is there for giving the jury less information about the legal standard? There's no dispute that the legal standard here is manifestation. There's no dispute that that standard does not require a formal diagnosis. What reason is there to give the jury less information about that legal standard? It's not appropriate for the attorneys to be arguing the law to the jury. It's the judge's duty to instruct the jury as to the law. And that required an instruction that at least mentioned manifestation, that at least mentioned the rule that a formal diagnosis is not required.
Mr. Burnett, every single trial I presided in as a trial judge, the lawyers always argued the law to the jury. They never missed doing it one time.
That may be, Judge Morris, but here there was something different going on. They were arguing to the jury whether a diagnosis was required. And there's an answer to that question. The answer to that question is a diagnosis is not required. And so it takes the judge to instruct the jury as to that answer so that there's no misleading confusion on the part of the jury. Well, is a diagnosis required or is it not? We know the answer to that question. Mr. Sales disagrees with my interpretation of Frazier. He says we've discussed the wrong issue in Frazier. What he is saying, what he is criticizing the Jewett decision from the first DCA and suggesting why you wouldn't need to certify a conflict is also supported by the Frazier decision. The Frazier decision says the critical event is not when an illness was actually diagnosed. This context involved class membership cutoff date rather than a limitations date. But Florida's decisional law regarding so-called creeping diseases is consistent with that formulation. So he's faulting the Jewett court for importing this class membership notion to statute of limitations, but the Frazier court agreed. And why did they say that? Because the instruction that was given in that case said the same thing that we wanted the court to say here to the jury. Defendants do not need to prove that plaintiff was actually diagnosed with a smoking-related injury prior to May 5th, 1990 in order to prevail on this issue. So respectfully, this court would be an outlier. Jewett and Frazier both support the giving of this kind of instruction, but what was given here was simply the standard instruction that makes no recognition that this is a creeping disease case that is subject to a special standard. Judge Morris, you talked about the 16-to-1 ratio here. I didn't hear Mr. Sales give you an example of a Florida case. There is not a Florida case, to my knowledge, that has such a high ratio. The Ballard decision is 18-1. In footnote 5, the Florida Supreme Court says no party has raised the constitutionality of the issue. So that wasn't dealing with these constitutional ratios. So yes, this is an award where that has, higher awards have been affirmed on appeal for punitive damages, but not.
He also, as you know, makes the argument in his brief that the ratio is more like 6.5 to 1 if you take the compensatory award before it's reduced for comparative negligence. But
look at the Goddard.
Yeah, tell me about that.
Sure. So look at the Goddard decision from the Oregon Court of Appeals. There's only been a couple of reports that have addressed this issue. Goddard from the Oregon Court of Appeals and Clark from the Sixth Circuit. And there was a dispute in the judges in the Clark case about which number you should look at. But both Clark and Goddard make this very important point. It's not fair to punish a defendant for harm that the jury has determined is attributable to the plaintiff. Reynolds is not responsible for that 60% of the harm that the jury attributed to Miss Durrance. The jury attributed that harm to Miss Durrance. And so you can't inflate the amount of punishment based on Miss Durrance's negligence. So that's why you need to use the reduced amount of compensatory damages. And to put a final point on this, when the Florida Supreme Court in the Sheff decision affirmed the 3-to-1 punitive damages award there, it cited the reduced amount of compensatory damages relied on by the First District in the Martin case. That award was reduced from $5 to $3.3 million. And it was the $3.3 million that the Florida Supreme Court cited in Sheff. So there's another reason to think that it's the reduced amount of compensatory damages that should apply. And when you use that reduced amount, so not the 500,000, but the 200,000, it's a 16-to-1 ratio. And I recognize
you're going to please wrap it up.
And for that reason, it's a due process violation. Thank you, Your Honors.
Thank you, Mr. Burnett. Thank you, Mr. Sales. Thank you both for a very good argument.
Very good argument.